Good morning. Good morning. My name is Paul Coquette. I'm a reporter appointed on behalf of Scottish ministers to carry out an examination into the Glasgow City Council 73 Rylees Crescent Glasgow Compulsory Purchase Order 2023. This is a hearing in relation to this order, and it's held under the Compulsory Purchase by Public Authorities Inquiries Procedure Scotland Rules 1998, and it's a hearing ahead of reporting to ministers on an objection by Paul Gillespie, who, as the owner of the property that's the subject of the order, is a statutory objector. A statutory objector is a person who is objecting to an order where they have a property right in that order. This hearing is being recorded for accessibility for parties who may be calling in to observe, or for future access of the recording of the hearing. The recording will be available on the DPA website by searching under the reference, which is CPO-260-5. For the purposes of this morning, participation in the call this morning is taken as consent for GDPR and data protection purposes. I know that Paul Gillespie, the objector to the order and landowner concerned, is on the call. I'm also aware that Michelle McCloskey of Scottish Government is on the call and but will not participate in the call. But in addition to them, the council is represented this morning, I think, by their legal team plus two witnesses, and I'll maybe just ask the council to introduce themselves and indicate who is here at present and in what role in this morning's hearing. And it's over to Mr. Latta.
Well, good morning, Mr. Coquette. I'm Paul Latta. I'm the solicitor who's representing the council today. Also in the room is a solicitor who's been promoting the order. The witness, Eddie Ward, is a principal officer for housing investment. He's available remotely. Alison McLaughlin, the senior empty homes officer, is a witness. She's currently in the room with us. We've also got, as an observer, Duncan Thompson, the group manager of the private housing sector at Glasgow City Council, and Catherine Kane, a trainee solicitor at the council.
Okay, thank you. And we have Mr. Gillespie present this morning. I think it's important to emphasise in relation to this hearing, which is a stage in the examination. There's been a degree already to which there's been documents submitted on behalf of the council. This is an opportunity for me, as chairing the meeting, to ask questions as to the justification and in relation to the objection. But Mr. Gillespie is present here this morning, and I know that for him this is an environment that is unfamiliar to him. And I'd like to assure him and reassure him that the intention of this morning is to make the process as informal and relaxed as it possibly can be in what are unfamiliar circumstances to him. The nature of a hearing is that I, as the appointed person, I will lead the discussion, and the questions strictly should and do go through me. But I'll give Mr. Gillespie an opportunity at any point to ask any further questions if I'm not covering or understanding any of his concerns. I'll give him a chance in a moment to say something by way of kind of general comments about what this process entails, if he wishes to do so. He doesn't have to do so, but if he wishes to do so, then he can feel open to do that. As I say, it's important that we hear his views and get understanding of the concerns that he has and reasons why he's opposing the order. What the intention for today will be is there's no set time for the duration of this call. However, it is my intention, as with most virtual meetings, to have breaks at regular time and probably around 11:30 we can take a break. It's quite difficult to continue for lengthy periods or virtual calls. However, if anybody wants a break for any other reason at any other time, then just say, and we can take some time out to ensure that people are as comfortable as they can at all stages of the process. This hearing, of course, although it's not the end of the process before my job to write a report that'll go to the Scottish Government on the merits of the order, it's not the end of the process, but it's equally not the start of the process. As I say, Mr. Gillespie has been involved and has indicated certain difficulties in participation in different sorts of processes that I won't repeat here. But we've gone through a number of processes. We dispense with a pre-examination meeting. I'm conscious that Mr. Gillespie is keen to obtain and has tried without success so far to obtain legal advice, and that he intends to continue trying to do that. It's very much the case that in processes like this, as indicated to him, he can attend if he's able to, and somebody is able to come with him, with a friend or family relative to support him in this process. And following this meeting, it's perfectly possible that there may be matters that are unresolved that require to be dealt with and can be dealt with in writing rather than necessarily a hearing, which is not necessarily a comfortable area or a preferable way to proceed. So we have a lot of flexibility after today, and at the end of this hearing, we'll give some thought to kind of next steps to ensure that any unresolved issues, we can have an opportunity then to take forward and address any unresolved issues. We have the witnesses on behalf of the council this morning, but there's also a number of documents that are lodged, and as I say, they're available on the DPA website, including policy documents, copies of the order, the statement of reasons, and other matters. Notice has been given of this hearing. It's been notified and published on the Glasgow City Council website, and I've had confirmation to me that a site notice was placed in a prominent position adjacent to the property at Rylees Crescent on the 22nd of January, and I'm grateful for that, for having been done. I made a site visit externally to the property on the 8th of January because of the nature of the property being boarded up. I obviously wasn't able to look internally, but I did have an opportunity then to familiarise myself with the property at that point. An agenda for this meeting, which can be applied fairly kind of broadly, we can talk other things as well, was issued on 25th of January on my behalf, setting out 4 issues for discussion. That is, firstly, the council justification, and in particular alternatives to compulsory purchase. Secondly, the council justification based on the consideration of the policy basis for the proposed acquisition. Thirdly, the issue of the grounds of objection, and then questions or issues raised by the landowner, Mr. Gillespie, who's here. But the 4th issue is what I'd like to hear, if we can hear from Mr. Gillespie, as to the question of what future steps could be taken as to remove the need to have the order. And we'll come to that in the course of this meeting. As I've indicated, the Glasgow City Council have provided a number of documents and statements which are lodged and are on the DPA website. That is the order map, an extract of the minute and report to the Contracts and Property Committee of the Council of the 6th October 2022, the title sheet and title plan, certain photographs of the property, a letter to the landowner of 26 November 2020, a letter to the owner of 4th March 2021, a set of email correspondence to and from the owner between April 2021 and May 2023, and the Glasgow's housing strategy for 2023 to 2028. We also have lodged witness statements, as I've mentioned already, by 2 witnesses present today, along with a grant letter to Wheatley and a copy of the district valuer valuation. The district valuer is Office of HMRC, the Revenue Office which carried out a valuation of the property in September 2022. Also, I have had regard to a range of emails from Mr Gillespie indicating through his MSP, Natalie Dawn, that he had difficulties in engaging with the process and explaining a little bit of the background, and he may want to say a bit more about that in a moment. So that's the sort of general context of the documents I have before me. I don't know, first of all, Mr Latta, is there anything you want to say about the agenda or about the other parts of the process to be conducted this morning as we take things through?
The agenda and your summary of how the procedure will be going today. Yeah.
Okay, that's all fine. And Mr Gillespie, is there anything you want to say about the kind of procedure and process for today? I'll bring you in a minute to see if you want to make a more general comments about the merits of what the council are seeking to do. But does that process for this morning sound okay in terms of how we deal with things? And as I say, at the end of the process, we can then decide next steps.
There is one thing I would like to point out first, though. I had actually discovered late this August, September, that this thing had been in the works since last October. I had no idea. Had that been the case, that would have given me time to get someone into the house, get a lawyer, or do something. It's basically been a mad panic for me since August, September-ish, trying to get a lawyer, trying to get things fixed up, do I start works in the house immediately? Is there any point? It's just basically been a total stress meltdown for me. Two, what is the valuation on the house? Because I didn't even know it had been valued, and if so, then because obviously the place where I am just now is not suitable for my health needs, and if this thing goes ahead, then basically I will never have enough money to buy another property. So that leaves me at another disadvantage, and I would also be interested in other remedies that would be possible, please. And I'm willing to work with the council, so that if there is any other remedies available, then obviously that would be great, yeah. But the fact that this has been going on since last October, and I only found out when I get served, what was it, August, September this year? I mean, that's totally outrageous. There's no emails or any notification at all from me, before I got those papers through. I had absolutely no idea that this process, that's a year. I could have done so much in a year. This could all have been sorted out within a year. So basically, that really isn't fair and puts me at an enormous disadvantage and basically makes this almost practically unwinnable for me. It's basically stacked the odds against me. I really don't think that's fair. Yeah.
Okay, well, there's a couple of aspects of that that were in my mind to ask about already, and we can talk about the kind of valuation. That the value document has now been lodged, and the council, I think, will probably have something to say about that, and may have something to say about the background history. That's
can you tell me how much that valuation was? Because I have seen that. I don't know that exists. Basically, I didn't know.
Yeah. Well, the valuation it's actually on the DPA website. You can have a look at that. The valuation letter from the district valuer puts the value of the property in its fully refurbished state as being £180,000, but in light of the condition of the property that it's in just now, the valuation indicated as being £60,000 as at the date of that valuation. So that's a document.
Yeah, well, obviously that
access on the website has been lodged by the council.
There's absolutely no way that I could buy another property if this goes through then with £60,000. Basically, that leaves me. I'm in a house which is basically unfit for habitation with my health condition. Basically that means I'm stuck here and severely disadvantaged. I will never have the funds to buy another property. The house valuation, although it is pretty low, is basically the house is sound inside. It does look quite kind of grim outside, but that's just basically a paint job and some landscaping, front garden and a new fence, and the inside painted and decorated, and some, you know, cosmetic stuff to do with the heating and whatever, and you know, painted and decorated. But before my mum moved out, my mum was physically and mentally and financially abused by my sister, and she was made ward of the social work department in Glasgow City Council, and basically they wouldn't let me take mum back home, and you know, the place got flooded and it got broken into and I had to board it up, and then we didn't have the funds to put it right, and it's just been one thing basically. So you know, things happen and just events basically, but I do intend to move back. Back to the property. It's just I'm not well enough. I've got 2 or 3 people lined up. In the meantime, you know, that can move in. Then, you know, once I can sort of get the go ahead, I can start ahead with the works. As I said, it's basically just a paint and decorate, some minor plumbing and decorating, and a new kitchen. And you know, and the house painted outside. It does look kind of grim, and the front garden re-landscaped and a new fence basically. And yeah, but you know, once obviously there's no point in me doing that, you know, if this is going to go ahead. So and then on the other hand, £60,000. I mean, there's not a lot I can do with that. It's never going to be enough, you know, to you know, for me to do anything with. Basically means that I'm stuck, you know, where I am in an unsuitable housing. You know, why should I lose out, really? You know, it's not fair. It really isn't.
I understand that. And you have indicated some of that in your earlier correspondence about the intentions that you had, both in terms of family use. I think you said your daughter at one point might have been a possibility, or you'd also raised the possibility of a short-term let. So you have flagged up those issues as possible. Possible solutions. We'll cover a bit more detail in the agenda. I'd like to explore a little bit of that a bit more. So I think that's fair.
Yeah.
So, Mr. Gillespie?
Yeah, you keep breaking up. I'm standing at about the connection. It's 4G. I'm on 4G, so I can't improve things any better. Yeah.
Okay, I know. Understood. That's all.
Just cut out.
Right.
Everything.
Yeah. Just before going on to the first item for the council, which is my list of questions around alternatives, just a couple of things. First of all, I wondered if Mr. Lafferty could just confirm now, or if he doesn't off the top of his head at some point later, the original advert for the order was a newspaper advert that was done. I wonder if you could just confirm which newspaper it was. I don't think that there's a certified copy of the advert, but I don't think it actually says which newspaper it was added in. It was advertised in, I should say. So.
Sorry, it was advertised in the Glasgow Times.
The Glasgow Times. That's fine. And just for the record, sometimes reporters ask, but quite that really comes into it, is I'm conscious that the property from my site is pretty major, but just for the record, can you confirm that the CPO subjects fall within the council area of Glasgow?
Yes, they're within the Glasgow City Council's area. Yeah.
Thank you. Okay, thank you. Right. The first issue is alternatives, and this ties into a certain degree that Mr. did already, and this is covered in terms of other enabling powers, other options, which is of the statement of reasons. And I wonder if you could ask your witnesses just to the record the history of the alternatives that were considered. I think there are a number of those, including demolition notice orders and statutory work notices. I wonder if you would just ask your witness to speak for the record as to other options that were potentially available to be addressing these issues.
Well, I was hoping the witness's statement could be taken as read, but yeah, I can certainly put that to the witness. Our witness on the alternatives to compulsory purchase orders is Alison McLaughlin, and she's with the Empty Homes section, Neighbourhood and Regeneration Services. So I've referred to her statement. It has been lodged in support of the case, but Alison, if you could please.
I'm just not sure, Mr. Gillespie. Sorry, Mr. Lancer. I'm just saying. Yeah. I'm just not entirely sure that Mr. Gillespie has necessarily seen that statement from the indication being given. So you might want to.
I haven't. No.
Read it. You may have to read it.
Alternatives, no, not alternatives to a CPO. I haven't.
To lead your witness under for the record, so Mr. Gillespie can hear the evidence.
Can I say something?
Yeah.
Could I step in, Mr. Cockett, if possible? So, in terms of alternatives to compulsory purchase, can you hear me?
Yeah, when it does break up, I'm getting every third word or something, but you're okay for now, yeah.
So there are two avenues. So first, the engagement with the owner. That was the big alternative to compulsory purchase, to which the witness Alison McLaughlin will speak, and also the statutory alternative enabling powers that were considered by the council, which were all listed in the statement of reasons. So if you wish, the first witness, Ms. McLaughlin, to speak or to read her statement, then she's here.
Yeah, or just read relevant parts of it, just so that Mr. Gillespie can get a sense of those particular issues. Good morning, I can see you now.
Morning. The alternative to compulsory purchase basically would be to occupy the property. There would be no other statutory notices that we would have put in that property, and my involvement with Mr. Gillespie since I first started speaking to him, and was always the end goal to have the property occupied. We investigated with Mr. Gillespie, I discussed and I investigated alternatives for alternative use for the property, but because there was never any access to the property offered, we knew that the property wouldn't be suitable for use by a partner organisation that we have. It was Y People at that point, it's now right there, so it couldn't be used or considered for temporary accommodation. I spoke to several other organisations about if they could maybe allow it to be used as a short-term let, but because the property wasn't of the proper standard, that couldn't be considered. I spoke to Mr. Gillespie, and I spoke to his daughter about his daughter Emma, about her possibly occupying the property, but Emma Gillespie couldn't get access to the property either, and couldn't come to an agreement with her father to occupy the property because she couldn't get to view it to see the internal standard of it. So Emma withdrew for that process and didn't want to occupy the property anymore because she didn't know what the internal condition was. So basically the council have only want to see the property occupied and brought back into use. And because Mr. Gillespie had provided a plan for the repairs and a timeline, and he never carried through with this. This is why we resorted to the last resort of compulsory purchase.
Can I cut in there, please?
Before I bring Mr. Gillespie in, one other question about. Yes, well, of course, you go first, and I'll ask my question in a minute.
Sorry.
Yeah, carry on.
The dates when we started to
I started working in this case in June 2019, and I first got direct contact with Mr. Gillespie in 2020. Mr Gillespie, I had written out a few times, and I finally spoke to Mr Gillespie in 2020, and that's when my engagement with Mr Gillespie started. I discussed the CPO with Mr Gillespie in April 2021, and tried to work with Mr Gillespie with the end result of seeing the property occupied from 2021 until we promoted the CPO, which I've discussed with Mr Gillespie on regular occasions, until we promoted the CPO in October 2022. I provided advice and assistance. I looked for alternative uses for the property, but the stalling point was always that the house needed repaired, and nothing was ever started, and no repairs were ever started in the property.
Okay, I think Mr Gillespie's wanted to ask a question. Right. I know the line's not a very good one of this. I can hear him just now, and then I'll ask my questions. Mr Gillespie?
Right.
Well, yeah, for a start, basically, I wasn't aware that the council wanted access to view the property. That wouldn't have been a problem, and I could still arrange that. That's fine. Two, I kind of feel that I didn't get off to the best start with Alison. I don't think she was aware of my autism, and I suffer from severe stress, burnout from basically, the last 20 years looking after my mum, and I've got a very, very low stress tolerance. So when it reaches a certain threshold, I just kind of I just have to withdraw, But I think maybe if I'd made that clear, that maybe communications, that certainly would have helped. And I'm still open to, working with the council. My only problem being that I couldn't get legal representation, to sort of come and go with the council, so that I could, so that obviously I could negotiate, and I could prove that X, Y, and Z is being done, with photographs, with, work progress reports or whatever. I'm still open to any kind of, I don't really understand what is a work something order something. Is that like an order to get up to a certain standard or whatever? But the house really, apart from being decorated and some minor repairs, which would basically be done within a few days, there isn't really that much wrong with the inside. All being it might not be up to maybe, insulation level or draft level, whatever for renting out as a private landlord. But I'm pretty sure that could be sorted, because, that wouldn't take too much sorting if the council was willing to work with me on that. I'd be willing to.
On that, Mr. Yeah. On that issue, Mr. Gillespie, I noticed that
to let that out to whoever.
Yeah.
Sorry. Yeah. You keep cutting out. So,
one of the documents that the council has lodged. Can you hear me now?
Yeah. You keep breaking up.
One of the documents. Yeah. Apologies. One of the documents that the council lodged is a series of emails, and at one point I think they'd had discussions with Alison McLavin around April 2021, and I think you sent an email with a set of proposals relating to works that was intended to be done at that point.
That was actually my daughter, and basically the problem is that I got sick around about February 2019,
right,
and that's when that all got kicked off. I got a septic arthritis, which wasn't caught in time. It spread through my body, and I've now got cancer. So I'm not actually well enough to move myself at the moment, but obviously, when I do finally get treatment, because I'm not planning on leaving this planet anytime soon, but obviously I'm going to need somewhere decent to stay, and I don't think that £60,000 that I possibly could be left disabled, and that house was adapted for disabled, and it's a solid house, and would be perfect for me.
Sure.
The place I am certainly isn't suitable, but if any works can be done, to bring the place up to category standards, for using for either, I don't know, Ukrainians or the Y project or whatever it's called now, then I'm willing to work with it, and whatever grants or whatever are available or can be applied for. I mean, that's no problem on my end anyway. I don't have any issues with that. But the problem with lack of communication with Alison, I think she wasn't aware of my autism and stress, stress issues, and I think we kind of there was a bit of a miscommunication or not clash of personalities, but obviously, I don't know. She just thought that maybe I was being difficult or giving her a hard time, which wasn't the case. But my mum got seriously ill round about 2019, 2020, just before the pandemic. She contracted ESBL. Now, that's a gram-negative E. coli in the bladder. And I don't know if you're aware or not, but there was actually a breakthrough. When was it? Just on January the 3rd, it was announced that there's a new antibiotic, but this is a life-threatening condition. My mum had been yo-yoing in and out of hospital as a life or death emergency for the last 3 years. Plus, I've got cancer and I'm housebound, etc. You can understand what a nightmare that's been for me. Plus my autism and stress, and the miscommunication problem with Miss McLaren, so that I didn't make clear about. So that's where we are, and that's why we're here where we are today. Basically, the thing about Emma moving in, basically, my mum had just been admitted to hospital, and I just couldn't deal with the stress of that, plus everything else. So that's basically the reason why that kind of didn't appear. But I do have my nephew, and there's a family friend interested in moving in, and Emma's still a possible. So I do need to get someone in there, to sort of house watch. Even if they don't pay anything, I really don't care. Just to live there basically, until I'm ready to move in. So that's my position on it. And if the council can use a property on a temporary basis for the foreseeable, I'm willing to apply for any grants, work with the council, or pay for as much as I can myself, basically, to get the place up to standard. If the council would be willing to look at that, I'd be willing to work with them. Yeah, certainly.
Can I come in on that, Mr. Kickett, please?
So that explanation, yes, it was absolutely, yeah.
For the very outset, I've spoken to Mr. Gillespie, he's made it very clear, and of his medical conditions. And the question that I've always asked and never received an answer to is why he would move into that property. The council, Glasgow City Council, only want to see that property occupied. That is what I've always stressed to Mr. Gillespie. At any point, and up until very recent conversations with Mr. Gillespie, I have assured them that if he'd moved into that property just now, then bring these proceedings to an end. There would be no need to go for a compulsory purchase order. The other thing I would just like to advise Mr. Gillespie is there is no council grants to help you bring that property back into use. If the repairs that you say that house needs would need to be funded by yourself.
No. What I actually meant was that if the council wanted to use it for maybe to sort of borrow it from me, if you get me, No,
Mr. Gillespie, I've had this conversation with you before, and and that's why I also put you in contact with a landlord support officer to explain to you you would need to become a registered private landlord. The house would need to be brought up to tolerable standard, and then we could consider consulting agencies for it to be used as temporary accommodation. So, but the responsibility lies with you, to bring that property up to standard, and it also lies with you to register as a private landlord. But we could have supported you through that, and we still would support you through that if you got that house repaired.
The only reason, basically, for the difficulty between myself and you was that 2019 is when I got ill with this. If I hadn't been ill, I would be able to go to the house, let people in and do the works myself, basically, and this wouldn't have been a problem. Also, with my mum lost her legs in 2017. She got septicemia. Then she lost her capacity and became doubly incontinent. In 2019, 2020, she got this ESBL thing, and she kept yo-yoing in and out as an emergency, basically. I don't know how many calls I got, that you better get down here quick because kind of thing. But finally passed away last October. But if I had explained my difficulty with stress and autism and stuff, I think that might have helped a bit more, because I think maybe you sort of possibly might have thought that I was being difficult, which wasn't the case. I was just basically snowed under with difficulties with my own health and with my mum's health, and it just couldn't have happened at a worse time, basically. So that's the reason for the difficulty.
Yes.
Yep.
Okay. So Mr. Gillespie, can I focus then on the suggestions that you had with your daughter had helped you, I think, in April 2021, with making a reasonably lengthy email with some details of costings and some identified potential workmen or companies that work could be done. And that was done in an email to Ms. McLavin on the 5th of April 2021. And I think you set an aspirational completion date of June of that year. Now, you mentioned a range of health issues. I'm interested just to properly understand why that particular bit of work didn't end up being progressed.
My mum, I think my mum just ended up in hospital as an emergency about that time, and it was pretty serious. And I just had a lot of issues with my mum regarding social work and funding and care homes, and she didn't just have this infection; she had a massive pressure sore in her, about the size of your fist, and plus she nearly died. So it was just too much for me, or we could have got that going. Yeah, that's the reason that didn't happen, basically.
Sure. And I think you also indicate in some of the correspondence that you didn't at that point have necessarily funding to do all of this, but that you do have the funding now. I think you indicated that. Do you want to say a little bit more about that?
I've got enough anyway to get it up to standard. Whether or not that be the standard for letting it out, I'm not really sure. But I've got enough to get someone in, a family member anyway, kind of thing. Definitely. It's just basically a new kitchen, some painting and decorating, and a new front door, and the central rating fixed because they get frost damage. Two of the radiators get bust, and there's some a burst pipe, that needs replumbing. But apart from that, the place is sound. It's bone dry inside, so it does look a bit grim from the outside. But that's just basically a paint job and a new fence and a new front garden, which wouldn't really cost that much.
Okay.
Are you still there?
Can I just go back to yes, still here? Yes, can you hear me?
Yeah.
Just go back to one other aspect I want to ask Alison McLavin about the alternatives, and I was thinking of whether there was any options of like repair notices. To statutory notices of any nature, as to whether that might have been an option. Or
what is a repair notice? Sorry to cut across you. Sorry. What can you explain what that is?
Repair notices on empty property. If they're not occupied, we wouldn't consider using that.
Okay. Yeah, that's what I want to explore a little. But a repair notice is where someone obviously is occupying property, and an alternative to compulsory purchase. I'm going to come to a more general question to the council on this just in a second. But as an alternative to compulsory purchase, things that came to mind, and the list is in the statement there as to what other options are available. And one of those options might potentially be to serve a statutory notice, a notice requiring you, Mr. Gillespie, to bring the property up to an acceptable standard. And I was just interested in why that wouldn't be an option as an alternative to compulsory purchase.
I could do that. Yeah, that's totally agreeable to me.
The answer
sure.
given. The answer given is it's not that wouldn't be appropriate in unoccupied properties.
Sorry, what are you saying?
So
I didn't catch that.
Last contribution.
I didn't get that. Sorry, I didn't get that either.
Okay, Mr. Gaggett.
We don't do improvement orders. We don't.
Yeah.
The council does not.
Yes.
So the answer to that is that So first of all, as Alison McLavin indicated, a work notice would not be served on a property that is unoccupied. Secondly, any such work notice would put the onus on the owner to carry out the repairs, which in this case, because of the background of the engagement with the owner, it is obvious that that wouldn't have happened. And
could actually still happen, because I do have like a family friend who's a builder, so, and does kitchens and stuff and home renovations, so I could actually get that done, you know, if the council was willing to work with me on that.
And also the final point that we wanted to make was that the tolerable standard applies to the property in relation to any person inhabiting that property. It doesn't have to be a formal let via the land registration scheme. It is a higher standard that has to be there.
Okay, thank you. I mean, in Mr. Gillespie's correspondence, his kind of final point that in his email that was sent through his MSP effectively asks the question as to whether compulsory purchase is appropriate and is necessary, and that's part of what we've just been discussing. And I guess, I mean, Mr. Latter brings up this you think is best able to answer this question. But I suppose my question is looking at the circumstances here of a property that's felt to be in poor state. Presumably many properties within Glasgow that are in a poor state. So my question, and I suspect Mr. Gillespie's question, is why compulsory purchase for this one? There must be many properties within the city that don't meet a high standard. So why compulsory purchase here?
What's the purchase on this? They can forward.
Mr. It's the property's been empty since 2006, and it's been identified as an empty home for affordable housing. It's a family-sized 3-apartment. And it's considered to be a blight on the neighbourhood. The property first came to the attention of the council from neighbours. It was the neighbours who first contacted the council. I believe it was a neighbour's daughter, an adult daughter, contacted the council with a view to purchasing the property and bringing it back into use. And subsequent to that, we've had various complaints from the neighbours that it has a blight on the neighbourhood. The owners haven't engaged with the housing association of the local area. I think it's a weekly group. When there was a redevelopment of the area, the housing surrounding number 73 has had new rendering, new roofing, new windows, and this house in the middle of the terrace has simply been left. It's been boarded up. We do not know the overall condition of the property, as there's been no access to the property. So it's in line with national and local policy to bring empty homes, empty affordable homes, back into into use, and with a 3-apartment or 4-apartment, apologies, it's identified as a specific house that can be brought in for low-income households, brought into use. And there are grants available to bring that property back into use. The other statutory powers are are available, but they're not appropriate in these circumstances due to the length of time this property is left vacant. It's simply unreasonable delay in occupying this property. I have to say, it is a last resort, a compulsory purchase order, but in the circumstances of a property being empty since 2006, it was then brought to the attention of the council in 2019, I believe it's July 2019, and through the course of that engagement with at that time, the joint owner, Paul Gillespie, he has made various indications that he intends to bring the property back into use in the private sector, and he has not brought forward those plans. He's not provided any indication that he has the finances to finance such a project. At each contact, he has a view of bringing the property back into use in the private letting sector, but has not gone through with that. You did indicate the emails of June 2021. That was the last sort of formal proposal that had been made to the council. Thereafter, the Empty Homes Officer, or witness today, Alison, had made various attempts to contact Mr. Gillespie, and he never returned calls. It was in July 2023 when the proposal was made to promote the compulsory purchase order. Since then, there has been further contact with Mr. Gillespie. I think it was in November when Mr. Gillespie made a proposal to bring the property back into use in December 2023. That date has gone and passed, and still at this date, there's no evidence of works on the property. There's no evidence of any plans to occupy the property. And at this stage, we are of the view that unless the property is occupied within a reasonable timescale, then it's appropriate to bring this property into use as social housing, an affordable home, by use of a compulsory purchase order.
Exactly why.
Yeah.
Hello.
Okay. Thank you. I'm going to bring Mr. Gillespie in. Yeah, I'll bring Mr. Gillespie for comments. I've one or two questions myself on the detail of that, but I wonder if Mr. Gillespie, if there's anything you want to say or ask Mr. Latta based on what he's just said.
Yeah, well, basically the problems with the house being empty with 2006 were down to Glasgow City Council Social Work Department. My mum was only supposed to be place of safety on a temporary basis, but they wouldn't let me take her back home. Then the place got water damaged and broken into, and my mum got ill, so it wasn't really appropriate. And that is the reason for the place being empty for such a long time. But no one has ever asked me to view the property inside. That's never happened. If the council can give me a timescale with works, as in a reasonable amount of time, I can get that done. I just didn't think I had the time to accomplish this, to get the works done and get someone in before this hearing, because I actually thought that this hearing was final decision date time. So without legal representation and having this explained to me how this procedure works, I'm afraid, which I just couldn't get access to then. So that's the reason, that I didn't go ahead with the works, because I didn't really see there was a point, because I saw this as a fait accompli, as in I didn't have time to get the works started. But I can get the ball rolling straight away if the council, if we want to set up a schedule or a timeline or sort of reconvene this, with giving me, a certain amount of time, to get a plan into, vis-a-vis a lawyer, you know, if I can get one, or myself, you know, if I can get the work started, you know, if I know how long I have, you know, and that this is possible, then I can get this done. No one's ever asked me for details on financing either. And if there is access to grants available, then I'd be interested in finding out about that. But I just want to get this sorted as quickly as I can, because it's very stressful for me, as you can understand. Yeah.
No, I understand. I think that there may be some difficulty, and it's not for me to comment on grant availability, but that may not be straightforward. I mean, certainly this process has commenced, obviously, but there's nothing to stop you and council officials continuing a dialogue separately from the process.
Yes, but how much time?
That isn't necessarily the end of the matter. So,
how much time would I have to get this done? I mean, if it's only a matter of weeks, then that's not possible.
Well, I think the important thing in terms of what you're saying is to embark, perhaps after today, and this needn't involve me because this is not part of my remit, is to engage in that correspondence. The length of time, I mean, I think the point that Mr. Latta was really making related to the lack of suggestions and even a kind of plan. The implementation of the plan is a separate issue, and a plan has to be implemented. But I think it's the absence of a plan, I think, is the concern. And the concern for me, looking at this, is if I'm reporting to ministers, do I have confidence that for whatever reason that hasn't happened yet, will it happen now? So any evidence of even starting a dialogue with the council would certainly help.
Who would I negotiate with? I don't have a point of contact. I mean, because I don't have a lawyer, I don't have anyone to negotiate, you know, on my behalf. So where would my point of contact be? So that I mean, if I knew who to contact, then I could get the ball rolling. Basically.
Well, I could probably guess, but perhaps the council can answer that question: is who the appointment would be? I mean, I'm guessing it'd be Alison McLavin, but maybe someone else.
Yes, that is correct. It would be Alison McLavin. But could I clarify one issue, please? Because Mr. Gillespie mentioned grants.
Please do.
He mentioned grants because my colleague, Mr. Latta, mentioned grants. Well, the grants mentioned are part of the government's funding for tackling empty homes in Scotland. So we referred to it in our statement of reasons. The government's Housing to 2040 confirms that powers will be given to local authorities to ensure that empty homes are brought back into use, and also confirms that owners will be supported to keep their homes to prevent homes becoming empty. But further down in that document, Housing to 2040, in Part 2D, relating to empty homes, that's pages 39 and 40, there is a paragraph mentioning that the Scottish Government will also establish a new fund for local authorities to apply to in order to bring empty homes and potential empty homes back into residential use and to convert suitable empty commercial properties in town centres. This fund will be flexible and adaptable, allowing local authorities to purchase the homes themselves for use as affordable housing, and it goes on about private owners to renovate home on condition that the home is rented on an affordable rent, and so on. So the funding mentioned and in this case relates to the Scottish Government's funding, encouraging local authorities to bring back empty homes into use. Yeah, so and we have our other witness to talk about funding if required by the reporter.
Yeah, okay. Maybe we talk a little bit later. I'd like to cover one or two slightly more detailed issues about Alison McLavin's evidence. Then maybe we can take a break and then come back and go through, I think, maybe some of the funding issues that may be something that can be appropriately referred to by Mr. Ward. And I'd also like Mr. Ward just to run through that policy background for Mr. Gillespie's benefit. So is someone else speaking there?
Is there any funding available for me to access, basically, not the council, if you get me? Oh,
Yeah, I wonder if Mr. Ward, if he has an answer to that question, that would help. But as I say, part of this can be continued offline effectively, I think, rather than formally in this environment. But if Mr. Ward has anything he can say about that further to what the talk has said, that would be helpful.
The grants I administer are solely for registered social landlords or housing associations. They're not available to individuals.
I mean, it may well be that a separate discussion, if there is scope, and I'm not hearing very much kind of potential for this, that these are discussions that are perhaps better taken forward offline for the reasons as said. But certainly conversations can carry on even in tandem with this, as I say, not involving part of the formal process, which makes it perhaps a little bit more relaxed. I had one or two more questions of Alison McLavin in relation to the issue rising. Some of which have partly been answered. I think my question was, how long has the property been unoccupied? And I think Mr. Gillespie indicated 2006. That's consistent with Alison McLavin's statement. And I just wanted to double check where you'd got that date from. But the impression I got is that was information Mr. Gillespie had given you. And I think he's just confirmed it on this call. So your evidence, I think, is that the house has been unoccupied since 2006. Is that correct?
Yeah, I get that evidence from our council tax records.
Oh, yeah. So regarding that,
okay, that's fine.
Yeah. There is actually a quite substantial council tax bill. Glasgow City Council Social Work Department, when they put my mum into a place of safety order, and on a side note, basically they closed down my mum's case and left her there and abandoned her, basically. So I had to fight to get her back out again. You know, that took me years with a lawyer. But they actually promised to waive council tax and care home fees. There's actually, charging order on the property. So, and the council tax as well. My mum lost her capacity in 2017. So that writes off half the council tax that's due on that. But not only do I lose my home, but I get hit with a £13,000 council tax bill. That's totally outrageous. I definitely would be challenging that because there's no way that my mum owed that, because my mum didn't have capacity for a start, and the council did promise to waive the council tax. So that's definitely something I would be challenging. I don't know what the council would have to recommend or to suggest on that front.
Well, yes, I don't work for council tax, but from my records, I did see that Paul Gillespie was always a joint owner of that property, and his mother, Patricia Gillespie, had exemption for her part of the council tax because she was in a care home, but a lot of the charges outstanding for council tax are solely Paul Gillespie solely liable for. And so that's for 2006, and the property's been in Paul Gillespie's name solely since his mother passed away in August 2022, and that is a substantial council tax debt as well now. But we're not pursuing the compulsory purchase order due to council tax debt. We are promoting, Glasgow City Council is promoting this compulsory purchase order, and we do it because we've got a partnering social landlord, because we're looking to bring properties back into use for social housing. The council priority is to provide housing for homeless households. And just to clarify one other point, we don't have any grants available for individuals or for empty homeowners to improve their property.
Can I cut in there, basically? Regarding council tax, Glasgow City Council Social Work Department promised to waive to freeze that, and that was basically that they went back on that, and my mum hasn't had capacity for years, so the council tax was in my mum's name. It certainly isn't what the demands I've been getting are. So I'm hoping that possibly could be resolved. And another issue: are the minutes of this meeting being taken for my lawyer, if I can get one in time, please?
Yeah, this has been recorded ever since we did the formal start of the meeting. This meeting is being recorded, so your lawyer will be able to access it by checking the DPA website under the case reference, which is CPO-260-5. Yes, this will be available along with all the documents. So it's not minuted as such, but a recording of it will be available for your lawyer to view. And can advise you in accordance with issues arising from that. My question on the social work issue is, I thought I'd picked up from this talk that the social work authority in this case was Renfrewshire rather than Glasgow City, and I thought that the charging order related to council tax, which obviously would be Glasgow City.
It was actually Glasgow City Council. It was the not govern, but it was under a Maureen Thornhill placed my mum under a place of safety. That was because she was being physically and financially abused, but it was only supposed to be temporary. But the council wouldn't, the social work wouldn't let me take my mum back home, and then the place got damaged, and then there was funding issues, and my mum's health deteriorated. So basically, the social work department are very much to blame for this whole scenario. I could have had my mum back years, and she could have had the enjoyment of her own home. I did actually promise I would get her home. So not only do I lose my mum, but I don't get to go home either. So yeah, yeah.
Yeah, so I'm happy to
the
answer.
relevance of council tax. It's because I'm supposed to bring you in. Actually, I was going to say, first of all, I mean, the relevance of this to compulsory purchase order is maybe I need to hear representations on the extent to which is relevant. But I wonder if there are some factual matters, if there's a factual dispute on this question, maybe this talk could give us an indication, at least the council's position, and we can take it from there.
So the council's records, the council's social work records show Miss Patricia Gillespie in the care of Glasgow City Council between 2006 and 2013, when she was indeed moved into care in East Renfrewshire. So that's the only time that she was actually under the social work services of Glasgow City Council. In terms of the council taxes, my colleague has said there was a council tax exemption due for Patricia Gillespie between September 2006, when she went into sheltered housing, and all the way until April 2020, when, as part of the empty homes investigations, it became known that the property was jointly owned, that there was somebody else who had occupancy rights as well to that property. Because up to that point, council tax thought it was mainly Mr. Gillespie's mother. Does that answer you?
So what's the interrelationship? Okay, what's the interrelationship then between the social work care that was done in the period you've said, and the question of the charging order and the money due in terms of the orders secured over the property?
Yes, so this is something...
what's interlinked?
So the charging order registered on the property only relates to the period of time that Ms. Gillespie was in care under the Glasgow City Council. The remainder period from 2013 until the date of her passing we assume it was covered via other financial methods. We are not aware of the financial arrangements between East Renfrewshire and Mrs. Gillespie or her attorney, that was Mr. Paul Gillespie, who held full power of attorney. So we don't know what's
Right.
happening there.
Attorney,
So this charging order only relates to that period of time when she was under Glasgow City Council care.
Can I just clarify something there, please? Glasgow Social Work Department actually promised to waive the care home fees. That will be documented in my mum's social work file. There should have been no charging order, basically. That should never have happened. Yeah.
Okay.
That's documented.
So I suppose
that can be proved. Yeah.
Yeah, so the essence of your position, Mr. Gillespie, is that you would dispute the charging order. You haven't disputed it yet, but it is now over the property. And the reason that this may have some relevance to current circumstances is that it might play into the question of how confident that ministers can be that the issues giving rise to the order will ultimately be addressed. If presumably the council's position is that from the £60,000 valuation of the property, the sums due under the charging order would be taken off that sum, and the money that would go to Mr. Gillespie would be the balance meeting the sum. I think the sum of around £13,000 was mentioned, and that would therefore reduce the amount of money available in order to do the any of the refurbishment. But Mr. Lasser, maybe you can clarify what your council's position is in relation to the sums due under the charging order, disputed as we hear by Mr. Gillespie.
Yeah, I could step in now because I have corresponded with the council's social work department, and I can read from an email which wasn't submitted to the DPA and yourself because of dealing with financial matters only rather than the property. So I'm reading. It appears from our digital records that Glasgow City Council funded the gross cost of Miss Gillespie's placement in Stanley Park from 21st of September 2006 until 4th of September 2013. And the reimbursement figure was calculated as 108,351.61 pence. The client's attorney failed to provide any financial information at the time of admission to allow a full financial assessment to be carried out, nor did they apply for free personal and or nursing care. So we are recovering the gross funded amount. However, they, that is the attorney, may still be able to retrospectively apply for free personal and or nursing care or provide information to complete a financial reassessment. So the position in relation to the charging order is that that is not a final statement. Mr. Gillespie will have to get in touch with the social work and apply for whatever benefits or entitlements that he can get and reduce the sum. And that is probably all we have to say in relation to that.
Okay, so the sum could be reduced then. Yeah. Well, that might be useful, Mr. Gillespie, to give some thought to that, to see what can be done, again, separately from this process, as a means by which that sum can be reduced, and that would give you more financial leverage to think in terms of the work that you've been talking about, or otherwise would avoid the situation arising that the compensation you get for the value of the property has the charging order sums deducted from that, which is obviously would be unwelcome to you. So that's maybe something for you to consider taking separately. But so I've got the point that you've not paid that sum because you dispute it. It sounds like there's an avenue forward for you to go.
I actually read in one of the emails that the council would just cancel the charging order. You know, obviously I don't want this thing to go ahead, but that was one of the proposals that they did. Can someone clarify that for me, please? Hello? Sorry, you've disappeared.
Council, it can be
I
clarified offline if it can't be today, but
no, there was never anything at all about care home charges discussed. That's absolutely out with our remit. I remember having a discussion very early on with Mr Gillespie about the care home charges, where I made it clear I couldn't and wouldn't get involved in trying to resolve the charges in the title, because it was out with my remit, and it's not even the same department. It's social work services.
okay. Again, the social work issues and disputes over that are not really for the compulsory purchase order. It's hard to see how they're really relevant to the issues before me. I'm going to take a break in a few minutes. Before we take a break, I did a couple of other questions for Alison and McLavin before we go on to other matters. In terms of the condition of the property, and Mr. Latta has given us some information about all of that. I think in your statement you narrate a number of times at which complaints were made, starting with contact. This is paragraph 4 of your statement. Contact that was made in June 2019. You then refer at paragraph 14 to several complaints about the property from neighbouring properties, the occupants of neighbouring properties, and photographic evidence was provided. Could you say a bit more about what the nature of the complaints actually were? What were the concerns, and what was the detriment to the area that the neighbours were complaining about?
The neighbours in the community were concerned. It was becoming a target for vandals. It also reduces a house in that condition, reduces house prices as well. Always becomes a target for vandals and the potential for people to break in. So that was the general concern of the neighbourhood, was it was bringing their neighbourhood down.
Okay.
And actually, sorry,
paragraph 38 of your statement, you made reference. Okay, Karen, sorry.
No, they actually went to the elected members as well. So the local councillors were in touch about the condition of the property.
Okay. And at paragraph 38 of your statement, you mentioned that between March and November 2022, some complaints were made from colleagues in public health.
Yeah.
Can you say a bit more about the public health concerns?
Well, the public health concerns where again it becomes just a target for vandals. People worry when there's a property in that condition that it's infested, and that's why they contact public health. It's just a nice one.
I actually, can I cut in there, please? I actually, one of the neighbours did complain, and I actually had to give access to an environmental health officer. This was, I can't remember exactly when this was, but it will have been documented, and the environmental officer found the place to be bone dry, no food source, no infestation. The place was fine, I mean, he actually was quite annoyed that people had wasted his time, but the place has been checked inside. There is no infestation, and I'm willing to give the council access to the place to check it out. There's no issue there at all, and that's actually, an environmental officer did actually get access to the property and checked it out. So I feel that I also feel that the neighbours complaining about the property there's a vested interest in there, because neighbours on both sides were wanting to purchase the property for their children. So I feel that may be that some of these complaints may have been vexatious in regard to that matter, as in giving them an opportunity maybe to get a property cheap. But that also, in my view, that actually fueled the complaints. Because one of the neighbour's daughters on one side, she wanted to actually buy it, as you have stated, and on the other side, they wanted to buy it as well. And both neighbours have made complaints, the same neighbours. So they definitely have got this there's definitely a vested interest there, for making these complaints. It's not the complaints were spurious, basically. They had a financial interest in making these complaints. So that certainly would explain, the reason for the complaints, in my view, anyway. Yeah.
That's new information that my colleagues in public health have inspected the property and found it dry, and I will follow up on that. I will find out, if you could remember the name, Mr. Gillespie, the officer, or when. Can you remember when that officer? Was it last year? Was it?
Oh God, no. It was a good while ago. I can't remember the name of the officer, but I can contact him, or you can contact him.
Absolutely. I'll contact my colleagues in public health and get that information.
Yeah. Okay.
Can you?
My last question. Let's go take a break in a second.
Sorry, I'm just. Could you tell me who arranged the access? Who met the public health officer at the property?
It was me. I let them in, and they inspected the whole property, and there was no food source, no water source, and they found the police dry down throughout, and there was no concern.
Mr. Gillespie, was this prior to 2018? Because that's when you've told me that was the last time you were at the property. So was that prior to 2018?
Maybe the last time I was at a property, but I have had other people check up on it, with.
Okay, thank you.
Just got a note.
Okay. And can I just double check my last question on this? Was the Glasgow? Is the council have lodged various photographs, and they appear to be from Google Street View of August 2019 to June 2022. Is that correct?
Yes, that's
correct.
Yeah. Yeah.
There
I
was.
certainly saw the property on the 8th of January this year, but I think yes.
Sorry. Yep. Those pictures from Google View. Someone had actually put some disposable refuge there. I had that removed. So and I do actually admit that the place does look pretty grim, but that's just basically a paint job and a new front garden. So and it would blend in with the rest of the properties. It wouldn't look like that. I do admit that it does look pretty grim, but it's amazing what a couple of coats of Santex can do. Yeah, definitely.
Okay, right. I'm going to take a break just now because we've been going on this call for a little while. I don't know how long parties would wish. I've just remembered
something else. Sorry, I did actually want to take my mum home around about roughly 2006, 2008, but and I was under the impression that that I got basically my mum was being abused violently and financially, and we had to get her out there to get my sister out the house, and then the plan was to get mum back in again. But social work were really not cooperating with me, and they basically said, to paraphrase, over our dead body, basically, it wasn't happening, and then they closed down my mum's case. So I really do feel that Glasgow Social Work Department have got a lot of responsibility for this whole mess, and especially my mum not being able to go back home. And it broke her heart, basically, not being able to go, and I had promised to get her home. So that's the reason why this thing dragged on for so long. So I'm laying the blame for this squarely with the Glasgow City Council Social Work Department, for their intransigence and for making things incredibly difficult for me and very stressful too. Yeah.
Okay. Right. I think I'm going to take a break now. I think we'll come back at 12 o'clock. We have a decent break, a cup of tea or anything. So we'll reconvene at 12, and then we'll go on at that point to address the other issues in my mind from the agenda, which is the policy background. Mr. Ward might want to explain a little bit more about the broader policy background. And then if there is anything further to be said about future steps, we have covered a bit of that already. And the other outstanding issues from my perspective. So I'll adjourn for 15 minutes and come back at 12. Thank you. hopefully we can look to be reconvening now. It's just 12 o'clock. Okay, bringing ourselves back just now. Let's see, Mr. Gillespie's here. I don't know if Mr. Latta is here as well. Is Mr. Latta back with us? Oh, looks like it. That's perfect. Okay, thank you. Okay, thanks. As I mentioned before the break, I think there's just a couple of issues. One question which will tie in before I bring in Mr. Ward, tied in with the question about future financial commitments. I think we have information from the council in relation to their commitment with Wheatley Homes, and I think one of the issues I need to be satisfied about in terms of the financial commitment is that there's a reasonable prospect that if the order were confirmed, the work could be done within 3 years. I think that's the guidance that the Scottish Government give on that, and I don't know if I've actually had confirmation precisely that of the timescale. I think there's an indication that authority has been given by the council, and obviously I've seen the letter of comfort, effectively the grant letter to Wheatley. But I wondered if Mr. Latta or Ms. Talk could just confirm that the 3 years timescale is something that is within contemplation by the council.
Yeah. Go.
Okay, so it will be myself who would answer that. So apart from the funding that Mr. Ward will talk about, there is an agreement, there is an agency back-to-back agreement signed between Glasgow City Council and Wheatley Homes that states that if confirmation is achieved, the council will transfer the title to Wheatley Homes, and they have undertaken to complete the repairs and bring the property back into use as part of the affordable housing stock in Glasgow within 2 years of the date of the transfer. That undertaking will also translate into a burden in the title, so it is a strong undertaking.
It'll be underpinned by that. That's fine. Thank you. Right. I want to bring in Mr. Ward, actually. I wanted to ask him anyway, just to kind of narrate, and I think it's in section 6 of the Statement of Reasons, just the general policy background and go through the various policies that are there. There's the Scottish Government Housing to 2040 strategy, there's the Homes Fit for the 21st Century, and the Council's own housing strategy, in particular from 2023 to 2028. Some of those documents, I think, are now lodged and are available on the DPA website in PDF form, which is the standard format we have. We don't access things through our website through web links because they can change over time. So we need to get something that doesn't change. So those documents are lodged. But I wondered if Mr. Ward, who's lodged the statement, might want to just explain a little bit more of the background of the empty homes policy of the council, and in particular for Mr. Gillespie's benefit, for the documents that have been lodged, which are lengthy documents, if you were able to provide paragraph numbers or indications as to where we could see anything relevant that he wants to bring out. And he can do that ideally as we go, but if that needs to be done subsequently, that's fine as well. But I wondered if Mr. Ward could just explain the policy context of the Glasgow City Council's empty homes policy, within which the council consider the facts of these circumstances fit. Thank you.
Mr. Piquet, can I step in here? Mr. Ward would be able discuss the policy. His witness evidence is primarily about the funding. Regarding the policy, we refer to the statement of reasons and the Scottish Government's Housing to 2040 guidelines at Part 2D, which is referenced. I mean, if you wish me to read out for the record the statement at Part 2D, the empty homes, it says in 2019 there were approximately 40,000 empty homes in Scotland. We have brought back around 6,000 empty homes into use since 2010 through our support for the Empty Homes Partnership and other initiatives. Empty homes are a wasted resource, and the Housing to 2040 vision requires us to go further than we have before. As a first step, we will work with local authorities to audit empty homes and determine those that should be brought back into use, and support the work of the Empty Homes Partnership and continue to roll out the approach across Scotland. We will give councils the powers they need to regulate and charge owners appropriately for homes lying empty, ensure they have the mechanisms to bring them back into productive use. We will create a support package for homeowners in trouble to help them stay in their home if that is right for them, and to prevent homes falling into disrepair or becoming empty in the first place. We will also establish a new fund for local authorities to apply to in order to bring empty homes and potential empty homes back into residential use and convert suitable empty commercial properties in town centres. This fund will be flexible and adaptable, allowing local authorities to purchase the homes themselves for use as affordable housing, or provide grants to private owners to renovate the house on condition that the home is rented out at an affordable rent for a set period of time. We will be open to innovative suggestions from local authorities and others in the development of the fund so that it can meet local needs effectively. So in terms of the national policy, number 73 has been identified as an empty home. Mr. Ward's statement is referring to the operation of the affordable housing supply programme budget. So that is ties in with the policy in the Homes for 2040. We also have a local policy at Glasgow City Council, which was in play at the time that this compulsory purchase order was sought. Under action, well, the local policies, the housing, the Glasgow City Council's Housing Strategy 2017-2022. The particular article on that regarding empty homes is at Action 11. Under the manage, maintain and improve the existing housing stock, confirms that financial assistance will be prioritised to include bringing empty homes back into use. This is at page 59, the last column, and page 60, the first column. The Strategic Acquisition Programme provides funding to assist housing associations to purchase privately owned properties, including properties which are long-term empty. So there's a national and a local policy to bring back empty homes back into use as affordable housing. It ties in with the overall strategy of dealing with the housing shortage, particularly in Glasgow. The stats on the housing shortage in Glasgow are, they're quite stark. There's a shortage of 3 apartment, 4 apartment, 5 apartment houses for families, and at an affordable rent for low income families. So we're tying in with that for the purchase of not just number 73. It's across the city. We're looking at any empty homes that could potentially come into use as affordable homes for low income families. And the policy, the national policy, is to consider compulsory purchase orders where it's appropriate. We've identified that there is funding available for this particular property, given the overall circumstances. I don't think I've really much more to say on that. We have Weekly Housing as a partner to bring the house back into use. You've already referenced the photographs earlier today, which identify a house that looks quite poor next to the rest of the surrounding properties. So it's been identified for a compulsory purchase order, given the overall circumstances. And if you wish to consider the funding, I would put you over to Mr. Ward.
Okay, thank you, and apologise for Mr. Ward if I was about to ask him a question that wasn't within his area of expertise. But if he wants to add anything about funding before I bring in Mr. Gillespie, just to complement those useful references, and I will look at those, and Mr. Gillespie can as well, on the general policy framework. Is there anything, Mr. Ward, that you want to add about funding? Then we'll bring in Mr. Gillespie.
Well, Mr. Latta referenced previous housing strategy. What he's read out is pretty much replicated in our current one, which runs from 2023 to 2028. And as far as funding goes, with a budget of over £100 million, there is plenty of money. The works and acquisition of this is tens of thousands. So setting funding aside for it is not a problem.
Okay. And your evidence is that the individual circumstances of the property in Rylees Crescent fit within that policy context, is what I'm taking from what you're saying, what both of you are saying.
Yes.
Okay. Now, Mr. Gillespie, these questions relate to the overarching policy context within which the council are proceeding. I suspect your interest is mainly focusing on your own individual property, but if you have any comments to make or any questions about these policies generally, this is a chance for you to do so. I'm not saying you necessarily must have questions if there aren't any, but if you have anything to ask or add about the overall kind of policy framework, then this is your chance to do so.
Not regarding the policy framework, but I definitely would draw to your attention that the valuation is based on a cursory outside look. Yep. I would like the house revalued. I can grant access, have someone to view it properly, because the house is far better condition inside than it is out, and the outside is cosmetic. So I feel that the valuation may have been maybe unfairly low. So I would like that redone, please. And number two is I would like to know what my options are for going forward, as in I can get work started on the property fairly quickly, but I need to know who I'm negotiating with. I need a point of contact, and I need to know timescales as well, how long I have before a decision is made. If I have time, a reasonable time to get this sorted rather quickly, ASAP, and a point of contact, then I can move forward with that, please.
Yeah, you're actually preempting where I'm going next in this meeting, to be honest, in both regards. The first thing I did say to you at the beginning, that I'd give you an opportunity to say anything you wanted about the valuation. The valuation report it has been lodged by the council, and it is on the DPA website for you to look at. You had noted that it was an external valuation only, and I certainly urge you to have a look at that and see the qualifications that are made of that. So that's useful to look at. So
if the council aren't prepared to revalue, with a proper, viewing inside and out, then I can get my own valuation done and submit that then.
Yeah, I mean, it's perfectly possible for you to do that. The issues for me are relevant to whether we proceed with the order or not. The actual amount of compensation you would get, because you are entitled to compensation because of the taking of this property if the order is confirmed. The actual calculation of the amount that you're due is done independently of me. So you're perfectly entitled to seek your own valuation, and the council. I mean, it is true to say the council's valuation that they've submitted was dated the 28th of September 2022 and is stated as valid for 3 months. And obviously, well more than 3 months has passed since September 2022, more like a year and 3 months, or perhaps even longer. So it may well be the council could enter into a discussion with you separately, but that I suspect will tie in with to a degree with the question of valuation and compensation, but it may tie in to the other aspect you're talking about, Mr. Gillespie, and that's the steps you might want now to be able to take. And in that regard, I think you have been given already an indication that Alison McLavin is the initial contact to be getting in touch. I think I'd say two things. One of which is to repeat what I said earlier, is the sooner you open up discussions, the better. I don't think it necessarily would require you to have done the work within kind of a couple of weeks. But if you start an engagement with them and that engagement continues, everyone understands that nothing can be done instantly. So starting and progressing the engagement is the key thing to do, I think.
I'm very, very keen to do that, but I need to know. I also need to know which lawyer for council to contact, because there's actually two. There's Julia Talk, and there's I can't remember the name of the other lawyer, but there's at least two lawyers working on this, and I need a point of reference that I can come back and forward with emails, either myself or my lawyer if I can find one. And also I will be in touch with, as soon as I can get work started, I will contact Alison McLavin, and she can go out and inspect the works, and she can go out and do progress reports. That's no problem. Obviously, if work is being done, then the place will be open every day, and she's willing to come, view the property as often as she wants, just to see how quickly. But the people I've got in mind to do this are very fast workers, and they do have a good portfolio of work, and I'm pretty confident I can get this done quick, because I really need somewhere that I can move into, because the place I am is got mold issues, and since I've got a systemic mold infection, and this is basically the cause of my illness, because there's actually 6 inches of water under the floor, because there's no damp proofing, and it's basically none of the houses where I lived had damp courses, so basically the moisture and the mold is in the atmosphere, and that's what made me ill in the first place. And possibly this could kill me, because I do have cancer, and although it is slow growing, it has spread. So I definitely do need somewhere suitable to live, because it certainly isn't my current, and there's no way I can afford. Could you give me a wee second, please? I've just got some mail I need to sort.
Of course, certainly.
Hang on.
That's okay.
Just confirming that the main point of contact will indeed be Miss Alison McLavin.
Okay. Yeah. I mean, wait, was the Glasgow? Mr. Gillespie back, but yeah, the Ms. Talk was just confirming that the main point of contact in practical terms would be Alison McLavin. Certainly, if you engage a lawyer, it may be of some reassurance to you that once you engage a lawyer, the great thing about having a lawyer is that you can leave communications between respective lawyers to them, and so once. If and when you're able to appoint a lawyer, then you will not get communication from the council direct. They will go through your lawyer, and that'll be Ms. Talk who will deal with that. So it's perfectly possible to set arrangements in play following this call that can allow those discussions to take place, and hopefully that can work for you. The only other thing I did, you asked about timescales. To a certain extent, as I say, I think but the key thing, I think from my point of view, is I am under the duty to report. And what my duty is to report on whether the order should be confirmed.
For the
So I want to just repeat that. I'm not quite hearing that.
Oh, do you hear me?
No, could you just repeat that? I can hear you now. That's perfect now. You were starting to explain what you need.
Oh, can you hear me? Can you hear me? I'm something going wrong with my connection. Can you hear me okay? Hello?
I hear you now, yes.
You can hear me then, yeah?
Yes, I
Sorry,
hear you now, yes.
the line went down. I had to disconnect and redial in again. Can you confirm
That's
if
okay.
you can hear
I've
me
got you
okay,
now.
please?
You're going through very clearly now, I have to say. Yeah. I'm
Yeah,
hearing you
that's
very
great. Yeah,
clearly.
the connection just went for a second there. Yes, sure.
That's okay. Yeah, we're just going through
Right, okay.
the context.
Who am I speaking to? Sorry, I
Councillor
didn't catch your
McLaren
name, Chair.
for this talk.
What's your name? Sorry.
My name's Paul Caquette. It's Paul Caquette. You should have it in correspondence, but Caquette is Cackette.
That's your name, yeah?
That's my name, yeah.
That's your name, yes. So I'm only getting every third word of what you're saying. Sorry. Hello?
Okay. What I'll do is I'll put my name on the chat bar, so you get the spelling of it there. So I'll just put my name on the chat bar just now, then you'll have me.
Mr. Caquette,
I'll have the spelling of it as well.
Mr. Caquette, I'd just like to, we've made inquiries regarding environmental health visit to number 73. We've got a record that there was a complaint from a neighbour in 2020 regarding rubbish in the back garden, and environmental health officers did visit, and they were unable to gain entry to the property on that date, and the complaint was not followed through after that.
Okay, thank you. Okay. Well, I think we're looking as though we've lost Mr. Gillespie. I think we may have lost the connection with Mr. Gillespie just now. But we'll just give him a minute or so to see if he can return. I think you can all hear me okay.
We should say yes, yes.
Yes.
We were in silent.
Yes, thank you. Yes. We may have lost Mr. Ward as well. That may be
No,
not so much a connection problem, but he may have.
I'm still here.
You're still there, sorry.
Yeah.
I've got a thing that says you've left the chat, but you clearly haven't, or you've rejoined. It may be there are connection problems that are. But Mr. Gillespie seems to have left the chat, unless he's going to correct me as well. Right. Can I suggest we just adjourn for 5 minutes and we can switch off cameras and mics? I'll contact our office and just see if he could be contacted again to get him back in. But I'll keep my eye on the connections and then reconvene rather than having us all staring at screens for a minute. So we'll just adjourn for 5 minutes. And I'll try and see if Mr. Gillespie can get back into the call. I think we're probably reached the end of the things we can deal with just now, but I'm anxious to have him back on the call to talk about next steps, so he's clear about where we go next. But we'll adjourn for 5 minutes.
Okay, great. Thank you.
Thanks.
Why isn't my camera on?
I think we lost you, Mr. Gillespie, but I think you're back now, which is good news. Can you hear me now, Mr. Gillespie? Are you able to hear me, Mr. Gillespie?
Yeah, I can hear you, but I was gone for about 5 or 6 minutes, so I didn't catch. I didn't get any of that. Sorry.
No, don't worry. We adjourned. Don't worry. We realised that somebody popped up in my chat bar said you'd left the chat. You must have been disconnected. So I've done nothing since you left, and I'm just saying I'm very pleased you're back. So that's fine. So I'm now going to reconvene. I'm going to ask others if we can just formally reconvene. But we'd seen that you'd gone, so we adjourned. So I think the point we've reached before is we're giving you contact names of Alison McLavin for discussions about the practicalities, and Julia Talk, who your lawyer should be in touch with. And if you're able to get a lawyer, I'd very much commend that lawyer gets in touch with Talk, but also contacts us in DPA as soon as they're appointed, and then communication can go then between lawyers, and that'd be very useful. What I was going on to say beyond that, in terms of my role, is, as I say, my role is to make a report to ministers with a recommendation. Even once I report, ministers will think about what they then do with that recommendation. But even if they recommend confirmation, that doesn't mean that the council will necessarily proceed with the order if you come to an agreement through the discussions and the works that you're indicating you want to undertake, the timescale for seeking the completion of title ownership is not really within my control. It's not actually within the council's control, which is why I say get in touch and start the process as quickly as you can. But my report needn't wait until you engage in those discussions, and you can proceed on that basis. The main question for me, which is probably my last outstanding question, and it's for Mr. Gillespie, is what I need to think about. It'll depend on your next steps with the council. What I need to think about is whether I should recommend refusal to confirm. In other words, the prospect of compulsory purchase should be removed at this stage. And my question, I guess, is what can you say to me that will encourage me to recommend refusal of the order at this stage? I don't know if you caught that. Mr. Gillespie's not getting that. I'm going to go back to Mr. Latter then to kind of give an indication as to his kind of sense of where we go from here and the next steps. I think we've more or less done all we need to for today. I think there could be further process beyond this. I'd indicated a suggestion that we give a fortnight for Mr. Gillespie to come up with anything further emerging. Now, that was with a view to the possibility he might not attend today, but he's been in attendance, but will want to reflect on what he's seen and heard. So I'm inclined to stick with that 14-day period and just review next steps at that stage. But Mr. Latter, I don't know what you think. What would your suggestion be?
I'm happy to agree that as a way forward. Give him another two weeks. It's a reasonable period of time for him to see if he can instruct a solicitor and get legal advice on the way forward for him. In this case, it's been quite a frank discussion today. He's made some very valid points. But it may be that he requires to seek legal advice, and if he can do that, then we're quite happy to have a 14-day adjournment.
Okay. So, Mr. Gillespie, is there anything else more you want to say to me today? And then we can talk about that 14-day period. Is there anything else you just want to add by way of kind of summary? I think I've got a clear idea of what your views are, but if there's anything more you want to say just now, that would be useful.
Hello.
Hello. Hi.
Yeah, I've been gone for the last 10.
Hello.
Yeah, I'm back again, but I've been basically gone for the last 10 minutes. So I don't know what was said when I was. So yeah. Did you continue with the?
No, you're fine.
I didn't catch any of the last stuff that you said about how we proceed further with this. So if you could recap that for me, please, could I didn't get any of it.
Okay, I'll repeat that. That's no problem. Yeah, don't worry. No, we adjourned. We realised we'd lost you, so we adjourned for a bit. But it's good that you're back. But essentially, what I was saying is that the suggestion is that we've probably heard enough evidence for today. This, as I said at the beginning, is not the end of the process. And when I wrote out before, we suggested giving you 14 days to see if you can get the ball rolling either on securing legal advice or starting the process of discussion with Ms McLaughlin and Ms Talk about your proposals and the way forward. My one question I had, I don't know if you have a view on this, is that there is before me, and I've got to report on this, a proposal for a compulsory purchase order. I guess my question is, should I proceed to refuse the order at this stage? What confidence can ministers have at this stage that these suggestions of doing the improvements will be fulfilled? Or should I proceed just now and if matters turn out that you're able to come to an agreement and do all of this work, the council would then not, they would not proceed with the order, even if confirmed. You know, what would be the basis be for me to refuse confirmation just now, on the kind of hope that agreement can be reached to improve matters?
Well, I'm hoping that I can get the balls rolling, started straight away. You know, within the next couple of days, I can start getting that arranged, and I can let Miss McLavin know, and I can also email Miss Talk just to let her know what's happening. Miss McLavin is free to come and inspect the books, and come and go, and email me or phone me or whatever. Yeah, certainly. I'll do everything I can to cooperate. What kind of timescale here are we talking about before a decision would be made on this? Just so I know how much time I have.
Yeah, sure. Yeah, I mean, the difficulty is the timescales for the actual taking of the property are not within my control or the council's control. What I was saying, and you may have missed this being not on the call, is I make a recommendation, and then ministers will take some time to think about it. But even if the order is recommended for confirmation, then there's a stage beyond that whereby the council then complete title to the property. And it's only then the property transfers. It's called the general vesting declaration. Now, I can't say how long away that will be. The council may be able to give you some guidance. It'll be some time away. It's not going to happen within the next 2 or 3 weeks. So if you can get the ball rolling and then keep momentum going, then even if the order's confirmed.
Sorry, even if the order's confirmed, sorry, could you repeat that? Do you mean even if the order's confirmed and I can get someone in, then they would cancel it, or what?
Yes, it's open to the council then not to proceed with completing title to the property. Now, Mr. Latta may want to say that. Would they be the confirmation process simply is.
Would they be likely to do that, though, if I got someone in? Would the council still want to proceed with that, even though the house was occupied? Is that a likely scenario?
Well, I'd have to ask the council that question as to what they will do. All I can do is try to give an indication to say that that nothing will happen very imminently, and I'm suggesting that if there's anything further you want to add, I suggested the date of 22nd February to get the ball rolling in terms of seeking legal advice and make contact, and I still suggest that's what you do. Beyond that, it's very hard to tell what the best timescale is going to be, because it depends on events that haven't happened yet. What council would do, I suspect, depends. Sorry.
Is there another hearing to make a decision, and who actually makes the decision, and when is that decision likely to happen, and what's the format of the arena for that decision?
Yeah, there'll be no further hearing. I don't see any need for a further hearing. What would happen next would be dependent on your next steps to take steps to persuade the council not to proceed with the order, or for me to recommend refusal. But if there's no grounds to recommend refusal, then the council would engage with you, and I'll let Mr. Latta say what he thinks would happen in that context. But it's not going to happen particularly quickly. As I say, I think I give you a fortnight to get the ball rolling, and then matters would fall then between you and the council. So, as I said at the start, this hearing doesn't make a decision. What follows from this is a recommendation that I make to civil servants in the Scottish Government, who will make a recommendation to ministers as to whether to confirm or not. But even if confirmed, if your steps are taken that satisfy the council, then they don't necessarily have to proceed with the order. But the timescales of that are impossible to say. All I can urge is to say everything really has to be as quickly as possible now. But Mr. Latta, do you want to say anything?
Well, it is difficult to give timescales for these things, but if the confirmation of the orders it's granted, it can take up to 3 months for from the date of confirmation for titles to be transferred, but we can't be exact about that. And I think, as you've already alerted Mr. Gillespie, it doesn't necessarily mean that the compulsory purchase order will be we'll be moving for the title. If he arranges for the property to be brought back into use, then that would be the end of the matter.
That's very helpful, thank you. That's a very fair indication, Mr. Gillespie, as to a way forward from your own point of view.
Can you confirm my email address and have all the relevant links and sent to me via my Gmail, please, just to make sure, because I wasn't sure if you...
I'll do that today.
If you can repeat that back to me, please, just so I know you've got the right address. Sorry.
Yes, I've got you. Yes, absolutely. I've got you at p.gillespie421@gmail.com.
Gillespie as Gillespie, as in my name.
Correct.
Yep.
As in your name.
Yep. Okay. Smashing, Mr. Crockett. Sorry, but yeah, I had to restart the actual app crashed twice, and then it wouldn't reconnect again. No. So I couldn't. Then it was asking me to sign in.
You back. That's the main thing.
What an absolute nightmare trying to get this thing to. Yeah. Yeah.
Okay. Right. Well, I'll do an email and get that out to you and copy to the council as well today. And as I say, if you get that ball rolling and continue your efforts to get legal advice on taking things forward, but as I say, if you keep my office informed as well, and we'll decide after 14 days where we are, and we can look then as to whether any further procedure, which could well be just in writing. There's no need to reconvene a hearing, given how difficult these scenarios and your circumstances are. It's perfectly possible that we can move things forward by way of kind of written communication with each other, and that might be easier for you anyway. But 14 days, I think, if we could, I'll review the case in 14 days, and if you could all keep me informed, progress at that point on the 22nd of February, by that stage, how progress is going, we can then consider steps. But I think Mr. Latter's indication of the timescales, this is not going to move in terms of completion very quickly. Ministers have a number of things to think about. So when they get my report, which I'd like to do reasonably soon, but when they get my report, it'll take some time to work that through. Even if they confirm, even if I recommend confirmation, then it'll take, as Mr. Latter says, potentially up to 3 months. But continue to talk to each other. That's the key thing. If you continue to talk, then that, I think, is the best way to ensure that there are no missteps along the road.
Well, I'd be talking with Miss McLavin and emailing Miss Talk, and I'd be emailing you as well, just to keep you in the loop.
If you keep us in the loop, I don't need to know the detail of the decisions and perhaps financial issues, but if you just keep me in the loop as to how matters go, up until the point that I report, I can reflect those discussions.
As in progress, to just keep you abreast of the progress. That's what you mean? Yeah.
Correct.
Yeah. Okay.
Yes, indeed. Yep. Perfect. That'll be ideal.
Yep.
Right. Okay. Well, unless anybody has anything else, I think I'll draw this hearing to a close, and thank you for your cooperation and your responses. It's not been that easy with the IT, but I think we've got there and get ourselves into a better place. I've certainly got a much better understanding of the issues, particularly from Mr. Gillespie's perspective. So thank you all again. And as I say, I'll commission an email to come out this afternoon on the points just discussed. So I'll close the hearing, and thank you.
Right.
Thank you.
Thank you very much. Goodbye.